Pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
You want me to?
Go ahead, sir.
So a few weeks back, I forget the exact number, but I'm gonna guess a month roughly.
Like roughly a month.
Yeah, we had a discussion here at the board level and we had a parent. We may have had more than one. I think we had a parent come in talking about kind of all the procedures around bullying, harassment, sexual harassment, Title IX type stuff. And at the time, we had talked about having someone come in to talk to the board, kind of explain things, and also to talk to anyone from the public that would like to be here. I don't know if the board is comfortable. I don't know if Mr. Wood is comfortable, but do you want to come join us at the table?
Plenty of room down here.
Yeah, it's a
That's-
workshop, so you're welcome to.
Don't worry, we won't make you vote or, sign up for anything.
Yeah, that's how you become, board member later. This is the first step.
Duct tape you to the chair.
You see how you sit, you see how you're working the chair first.
So,
Might be.
so we had Meghan Glynn from Drummond Woodsum come out and speak to all of our staff at the beginning of the year. And at that particular occasion, I did say that Meghan was my sister,
Yes.
which really threw people off because they were like, you're a brother from another mother kind of a deal. But Megan's specialty area, if you're going to have a specialty area, is in this particular realm of Title IX and harassment. She has unfortunately had the privilege of doing a number of investigations for me in the past. And the good news is they've always come out the way we wanted them to. The bad news is there are people no longer working, which could be the good news. So Meghan is here to give a brief presentation and answer any questions. Well,
It's not that.
chit chat. Well,
Yes.
it's lawyer brief, what, 2-3 hours?
Yeah, exactly. We'll be home tomorrow, don't worry.
So. go ahead, it's all yours.
Hey, everybody, nice to see some of you again, nice to meet some of you. I am Meghan Glynn from Drummond Woodsum. I do a lot of work in the student rights arena. So that is generally investigations on bullying, investigations on sexual harassment, sometimes investigations on Title IX, school discipline, all of those kinds of things. And you are right that this is an incredibly complicated subject, a group of subjects. I would bet your administrators would agree with me that these things overlap in ways that you don't always expect them to overlap. So I'm great at talking forever. So I would encourage you to please interrupt me. Whenever you have questions, you're not going to throw me off. I can get right back on my train. Don't worry about it.
You learn that in law school, don't you?
Yes, yeah, it's a required class,
It's a required
actually.
class, yeah.
You just talk for hours and hours. And if you, yeah. So please feel free to interrupt me at any time. We can revisit topics, we can eliminate topics that you're not interested in. This is sort of intended to be a general overview, but we can go deeper on any issue that you want. So. If it works. They don't teach you how to use a clicker in law school.
They should.
They should, they don't. Maybe I should go.
No,
I made your voice activated to hear
Try now.
there you go.
All right, thank you very much. Okay, so we have three basic groupings of laws that we're talking about when we talk about these subjects. The first one is Title IX, which is a federal law that prohibits discrimination on the basis of sex in all schools that accept federal funds. So that's you, right? The Fall Mountain School District accepts federal funds. So you are subject to Title IX in all of your education programs and activities. The second grouping of laws is a little more complicated. So Title IX is a standalone law, right? If you Google Title IX, the actual law will come up. Harassment is a bunch of different laws that play together, right? Sometimes nicely, sometimes not so nicely. So we have federal harassment, anti-harassment laws, like Title VII, which is an employment law. So if we have employees, which of course we do, then they are protected under Title VII, and it prohibits harassment and discrimination of all kinds. So could be sexual harassment, right? That's one, but it could also be racial harassment or discrimination, harassment based on ethnicity, religion, economic status, marital status. There are all kinds of things that go into that equation. So that's our federal law that applies only to employees. Then we've got state laws, right? They're companion laws. And RSA 354A is our state anti-discrimination statute. That applies to both students and employees. So it says we can't discriminate against individuals, employees, or students based on their membership in a protected class. And again, that is things like race, religion, economic status, marital status, sexual orientation, gender identity, and sex. So in all of these categories so far, we have sexual harassment, but Title IX is a heightened level of sexual harassment. And then, sort of at the bottom of the totem pole, so to speak, we have bullying. Bullying is a state law that prohibits intentional harmful conduct and hostile educational environments. Bullying has to be pupil to pupil. So it only applies to our students when they are doing things to each other, right? It has to be targeted towards another student. Harassment can be student to employee, it can be employee to student, employee to employee, student to student. So there are all kinds of different permutations there. Not all bad behavior rises to the level of bullying, right? We have like sort of a lot of unkind or mean behavior. I bet your administrators can attest to this, that we don't treat as bullying because it does not rise to that level. Similarly, not all bullying behavior is sexual harassment, racial discrimination, etc., right? It doesn't all rise to that level of illegal discrimination. But once we have decided that something is illegal discrimination, then it is automatically bullying behavior, because the definition of bullying is easier to establish than the definition of sexual harassment. So we have behavior that's bad enough to be bullying, then on its own, right, it's okay. But if we have that behavior that's bad enough to be illegal discrimination, some kind of harassment or discrimination, then it is also bullying. Does that make sense? So we get a lot of different calls from parents. We get a lot of different statements from students that we should treat something in a particular way, right? You might hear from a kid, I'm being bullied by another kid. And part of the administration's job is to speak to the students or the parents and say, okay, tell me what's really going on here, right? And a student or a parent might say, well, Johnny wasn't very nice to me and during snack time today, and he said my snack smelled bad, right? And that I'm being bullied because of that. If I heard that, I would say, that's not enough. And I hear you, Johnny, saying to me that you're being bullied, but I know that the legal definition of bullying requires something more than having hurt feelings in that particular moment, right? So I don't have to launch a bullying investigation just because Johnny has used the term bullying, but it is up to your administrative staff to have a nuanced enough understanding of the different definitions so that they know what their obligations are, so that they know if a parent is reporting something and they say, not only is this bullying, but maybe this is sexual harassment, right? Maybe this is Title IX, maybe I need to call the Title IX coordinator. They need to have that understanding of how these different laws intersect so that they can make those reports. Title IX sexual harassment has a very specific definition that is different from any other sexual harassment definition that you will encounter. And this definition, it was new in 2020, came out in May of 2020, went into effect that August. You guys might not remember because you were probably a little bit busy dealing with COVID, right? Like you had some other things on your mind.
It was harassing us at the time.
Yeah, I mean, there was a lot going on back then. But these regulations went into effect in 2020 and they are slated to change again. So this is the definition as it applies right now. Call me in June. I bet you I'm gonna have a different one for you. But today, sexual harassment for Title IX purposes only falls into three basic categories. The first one is quid pro quo. So that's where an employee of the school district conditions some kind of aid or benefit on engaging in an unwanted sexual relationship. So it could be a teacher saying to a student, right, if you want a better grade in this class, here's how you can get it, right? That's horrifying. It happens not very often, but it happens occasionally. And that is quid pro quo harassment. Similarly, if a supervisor is conditioning getting a good evaluation or getting a pay raise on engaging in some kind of a sexual relationship, that would be quid pro quo. Another important thing that I always tell teachers and staff members when I am meeting with them and talking about this issue is that OCR, the Office for Civil Rights, which falls under the U.S. Department of Education, is the entity that enforces Title IX. And OCR has taken an incredibly broad interpretation of quid pro quo sexual. So we are seeing situations where if a student doesn't feel like they can say no to a staff member, then OCR is considering whether that could be quid pro quo harassment because the staff member has the ability to condition the child's grade on whether they allow that conduct to continue, right? So there's been a real uptick in reports of students saying things like, I don't like how closely my teacher stands to me when they are, I have like a million thoughts here.
Ryan over here.
Thank you, you're welcome. So they're saying, I don't like how closely my teacher stands to me, right? That's making me uncomfortable. But I don't feel like I can say anything to my teacher because I'm getting a really good grade in this class. And I'm afraid if I complain, then I'm gonna lose my good grade in this class. Or I don't want to tell my coach that it makes me uncomfortable when she puts her hands on my shoulders because I want to be captain of this team, right? Or I want to make this team, whatever the thing is. So OCR is looking at those kinds of examples and saying that could be quid pro quo harassment. So I always tell the teachers that, and then I cite Arrested Development and tell them no touching, right? Try to keep your hands off students. Obviously, that has to be on a varying scale, sort of depending on the age of the kids you're dealing with. A kindergartner is going to launch themselves at you and give you a hug, and there's not that much you can do about it, right? But for our older students particularly, we want to make sure that we have firm boundaries.
I'll be right back.
The second category, the one that we deal with the most often, is hostile environment harassment. And again, this is under Title IX only. It's where we have conduct based on sex that is so severe and pervasive and objectively offensive that it effectively denies a person's ability to access the school district's programs and activities. So that applies to students, it applies to staff members because they also have rights under Title IX. That's a very high bar, right? It has to be severe, also has to be pervasive, also has to be objectively offensive. And on top of all of that, has to effectively deny someone the ability to access their education. When I'm looking at that, I am looking at things like attendance, right? How is this person's attendance? How is their participation? Have they stopped coming to activities that they used to come to? Those sorts of things. The old guidance had a much looser definition of sexual harassment, which was more closely aligned with Title VII, our federal employment statute, that said conduct had to be severe or persistent or pervasive and had to limit the student's ability. So you can see that a lot more things would be characterized as Title IX violations if you only have to have one category and has to limit, right? But here has to be all four things: severe, pervasive, objectively offensive, and denying the person the ability to access their education. Are there any questions about that? Sexual assault, dating violence, domestic violence, and stalking, these all fall under Title IX. I don't want to spend a lot of time going over this particular definition, except to say that if you have a sexual assault that occurs in the context of school programs and activities, that is a different definition than the hostile environment, right? We're not saying, was it severe enough? Was it pervasive enough? Was it objectively offensive? We're just saying, does it meet the definition of sexual assault? And if yes, we would treat that as a Title IX matter. Dating violence, domestic violence, and stalking, again, these all have to take place in the context of school programs and activities. So it's not super common, but it's not impossible that you would have some situations of either kids dating each other, right? That could be a possible dating violence situation. Or if you have adults, staff members who are married to each other, there's a possible domestic violence situation. But these tend to be pretty uncommon. In all of these cases, retaliation is strictly prohibited. So anytime you have an investigation of any of the types that we've discussed, bullying, harassment, sexual harassment, we always prohibit retaliation. And we do that based on the law, right? The law tells us you have to prohibit retaliation in these particular cases, which means we get to discipline separately. If we find retaliatory behavior, we get to say, no, we're not waiting until the end of the investigation. We are addressing that behavior right now. We have to respond to sexual harassment, which occurs in the context of school programs and activities. So everything that occurs on our facilities, right? And also, if it's off school property, but still in the context of a school program, like a field trip or something like that, we still have a responsibility, especially where we have substantial control over the person who has engaged in the allegedly harassing behavior. So if you send your kids on a field trip to the movies, right? And the ticket taker at the movies, I don't know if they even have those anymore. It is all scanned at this point, but let's say there's a person there receiving the tickets and that person engages in harassing behavior, right? That's not a Title IX issue for the school district because we don't have substantial control over that person. But if one of our teachers who is going on the field trip engages in harassing behavior at the movie theater, it doesn't matter that it happened at the movie theater, right? We have substantial control over that person in the course of their employment. So we have an obligation to respond. Also, very strangely, it has to occur in the United States. So if you're sending your kids to Canada, right, then the Title IX does not apply. I would stress very, very strongly that we still have an issue that we need to deal with, and we would still do other kinds of investigations. We would still take measures to ensure students and staff are safe. We just don't apply Title IX. This is something else that is slated to change with the new rules. So talk to me again in June. We'll see what we come up with. This is very in the weeds, but there is a difference between a report of sexual harassment and a formal complaint. I am focusing on this part mostly for the parents who have joined us. Thank you, parents. Reports of sexual harassment that go to the administrative team do not automatically entitle a parent or a student to a Title IX investigation. So they may file a report and say, hey, Principal LeClaire, right? Here's what happened, and I think that this should be investigated. And Corey's going to look at that document and she's going to forward that information to the Title IX coordinator. And the Title IX coordinator is going to be the person who decides whether it is a Title IX level complaint or not. Because the allegations, if true, have to reach that level that we just talked about, right? We have to, as alleged, the conduct has to be severe and pervasive and objectively offensive and deny somebody the ability to access their education. So the Title IX coordinator may look at that document or that listen to what has been reported and say, this conduct, even if it is true, does not rise to the level of Title IX. So let's talk about other ways that we can address the conduct, right? We might do a bullying investigation. We might do state law sexual harassment investigation, but the Title IX coordinator has to decide that label. If you want a formal Title IX investigation, or you want to be considered for a formal Title IX investigation, a parent or a student has to submit a formal written complaint that lays out all of the allegations, and then they have to actually ask for a Title IX investigation. That seems silly. That is the way the legislation is written. So we have to require that formal written document. So the report goes to the administrative team. They pass that information on to the Title IX coordinator, but the administrative team is not actually deciding, am I treating this as a Title IX complaint or not? That is somebody else. Any questions about that?
Does Title IX coordinator then talk to the parents and ask if they want to form?
So the Title IX coordinator, unless in many cases, the Title IX coordinator will set up a meeting with the family at that point to get more details, to explain the different processes. Because they may meet with a family and say, look, here's what the Title IX investigation process entails. It is incredibly long. It is incredibly legal is the best way that I can sort of think of to say it. It is very adversarial. And a family might say, we don't want that. We just want the bad behavior to stop. And so the Title IX coordinator is allowed to consider the family's wishes in deciding how to proceed. And there are certain circumstances where the Title IX coordinator may have to help a family prepare a written complaint. And they are permitted to do that in some cases where a student or a family cannot prepare that complaint on their own. So yes, there is generally a meeting. Part of the rules under Title IX. So once we get to the point where the Title IX coordinator has assessed the information and the family has filed a written complaint and we're in sort of formal Title IX investigation land, right? We then have certain legal obligations as a district. For example, we have to offer supportive measures to the complainant and the respondent while the investigation is ongoing. These are measures that are designed to allow the students to access their education while the investigation is going on. We have an obligation not to assume that the respondent has engaged in the bad behavior before we have the results of an investigation. So when we are doing a formal Title IX complaint, there is often a presumption that we can put a burden on the student who is being accused of harassment while the investigation is ongoing in order to allow the complainant to fully access their education. We used to be able to do that under the old rules, but once these rules took effect in 2020, we're unable to do that now. We have to treat both students equitably in terms of the process, and we have to make sure that we are not presuming responsibility. And that obligation is so strong that the district is required to actually put in the notice letter to the complainant and respondent. We are not presuming responsibility on the part of the respondent until we have some kind of a finding that tells us who is responsible. Yes.
So that makes sense. But how do you protect a student during this process? Because it could be drawn out and it doesn't matter what the finding is at the end, the damage can already be done to a student for a long, long time.
It will be drawn out. You're absolutely right. So this process is functionally a minimum of 60 days. And that's assuming that everything goes like a well-oiled machine, right? So it's a really long process. We try to do things like making sure that kids have no contact orders so that they know they're not to talk to each other while the investigation is ongoing. We try to do things like making sure that both students can continue to access their classes and their activities if they have shared activities by adding extra bodies to the room, right? So we don't tell a student who has been accused, you can't go to calculus anymore because we only have one calculus class, right? And that would be an undue burden on the respondent. But maybe we're putting an extra para in that room to make sure that those students whose seats have been moved, to make sure that they don't have contact with each other, right? To make sure that they don't, in fact, have any contact during that class. So it tends to be pretty fact specific, based on whatever the student is alleging and where the student is alleging that bad conduct to have continually occurred. But we do try to put those supportive measures in place to make sure that both kids can continue to access their education. And we have, it somewhat depends on, usually the big issue is classes, right? Sometimes kids have classes together. And if there are different sections of the same class, you can move one student without unduly punishing them. But if you only have one section of the class, then you can't tell a student who there is no finding yet that they've done anything wrong, you have to leave. There are limited opportunities to remove a student from school under a Title IX investigation. Those are only in situations where the student is expressing harm, threatening behavior to themselves or others based on the conduct of the investigation. And that is only for a period where the student can sort of get a hold of themselves and then safely return to school. So we're not looking at kicking a student out of school for a week or 2 weeks. We're looking at saying, okay, do we need to remove someone for 48 hours while we conduct a risk assessment and allow that student to safely return to the classroom? Yes.
What about, like, all school activities or after or sports or after school things where they might both be on the same sports team, or they might both want to go to a sports event?
I would say that students who are on the same team should be during the pendency of the investigation. And remember, this is only when we're doing a formal Title IX investigation that these particular rules apply. But if we are in the middle of a Title IX investigation and you have 2 students who are on the basketball team, for example, those students should be allowed to continue to play. But we need to make sure that those students do not have anything more than incidental contact with each other. And I would argue pretty strenuously that if basketball is the sport, right?
Yeah.
That those 2 students can't play on the same string, right? Because if they can't have physical contact, we have to make sure that there's no physical contact between those kids. So we would have to work with the coach and work with the athletic director to make sure that both students were allowed to continue to practice, allowed to continue to play. But in a way that's designed to minimize contact. It is not easy.
No.
I am sure that your administrative team is painfully familiar with all of these things, because trying to balance competing interests is virtually impossible. But an effort for sure would be made. And we don't have to offer, we don't guarantee particular supportive measures that someone might request, right? The school does their best to meet a student's needs. But you know, we aren't obligated to grant every supportive measure that someone might request. What we are obligated to do is to implement supportive measures that are reasonably designed to help students access their education while the investigation is ongoing.
So you couldn't send one student home with a laptop for the duration of an investigation.
No, that would be against the law.
You know, that's how you create active shooters, right?
I'm not going to answer that. I think that's a rhetorical question, but the law is very clear that we could not send a student home with a laptop for the duration of the investigation, assuming, right, that student did not want to go home and learn virtually for the duration of the investigation. The rules are pretty clear that you couldn't do that.
Do you think this will change in June?
I think that this distinction between reports and formal complaints might soften a little bit. I don't know that the obligation to treat complainants and respondents equitably is going to soften that much. These rules were particularly designed to provide additional due process to students who had been accused of sexual harassment. So I do expect that there is a push, I think, from the current Department of Education to make it easier for students to file these complaints. Because these is pretty hard. This is a pretty high burden to ask students to go through the report process and then the formal complaint process. And then, have supportive measures like this, but I do think that it will hopefully be a little bit more user-friendly for students who feel like they have been victimized, to access this process.
Did the law change in 2020 when a report was made that the accuser gets copies as well of every written
Yes.
statement? Because
Yes.
that was new and that
Yep.
made it very hard for, people who felt they were victims.
So yeah, not just the accuser, both parties, but yes, certainly, the person who is being accused, the respondent, that's the nomenclature under the law, receives copies of all the evidence, both parties do. So when the Title IX coordinator or your investigator conducts this investigation, they do witness interviews, they take notes, they create summaries of the witness interviews. And oftentimes students will contribute documents, right? Emails, copies of screenshots, Snapchats, et cetera, and those all become part of the record. And all of those copies get shared with both parties and they have 10 days to review and respond.
In those scenarios, you redact.
Limited redactions. So for example, if a document contained a social security number or an address, like something that was not pertinent to the investigation, then yes, certainly we would redact that. But in general, the information goes out unredacted to allow both parties the opportunity to review and point out inconsistencies. So basically, they get 10 days to review and respond in writing to the Title IX coordinator about the substance of the evidence. So they can say, hey, I see in your interview with Johnny, you didn't ask Johnny about X. And that was the most important question you should have asked because that unlocks the key to why. Or, I see that Johnny included these, poor Johnny, he's taking a real meeting
Johnny
today.
gets it.
Yeah, but I see you included copies of these screenshots and my copy of the screenshots looks really different, right? These text messages are edited. Here is an unedited version of the text messages. So we don't redact a lot of information that could be of merit in the complaint.
The student names stay in.
Student names stay in.
Do you have any idea how many formal complaints were filed in any given year?
I don't know. I can tell you that it has gone, in my experience, it has gone way down, the number of formal complaints that have been filed. In 2020, we were, that year is not representative, right? Because we were still dealing with COVID. A lot of us were in hybrid learning, et cetera. This year, we've seen an uptick in formal complaints, but it's still a much smaller number than the number of Title IX complaints that were being filed in, for example, 2019.
So what I'm getting at is, would you have any idea what percentage of the formal complaints were founded as opposed to unfounded?
I don't know off the top of my head.
Because it would be interesting to know if 100 complaints were filed and 90% were legit founded. And out of that 90%, not the respondent, but the other,
The complainant,
nomenclature.
yep.
the damage is done.
Yeah, I mean, I can tell you that there are a lot of cases that I have seen where the allegations are founded. So, for example, we are finding, yes, the conduct happened, but the conduct itself does not meet that definition of sexual harassment that we've talked about. So that happens sometimes. And when that happens, I think that there is some kind of understanding that schools have like a super secret toolbox that they can apply when we have a Title IX violation, right? And there's not. We just have the same options to discipline students as when we are dealing with a bullying investigation or a state law sexual harassment investigation. The the restorative justice and the discipline options are exactly the same all across the board. So I don't disagree with you that this is a long process, but if we get to a point where we say the conduct is founded, but it doesn't rise to the level of Title IX, your administrators are looking at, okay, but what other bucket does it fall into, right? Does it fall into a bullying bucket? Does it fall into a state law sexual harassment bucket? And if the answer to that is yes, they have the exact same ability to discipline those students based on violations of those rules.
Now, Title IX is federal, Title VII-ish is the state. Doesn't, like, when you talk about municipalities, whatever, the municipality can make a law more strict. Can't make it easier, but more strict. Would the school board have that
So
ability?
the school board has the ability to impose stricter standards of conduct, right? So your student code of conduct could say, you know, federal law doesn't preclude students from holding hands in school, from engaging in PDA. School board's going to preclude it, right? We are going to prevent that, absolutely. But you can't change the various standards under the law. So you can impose different rules, but you can't change the way that the standard applies.
What if you had a resource officer, would that change? Because I'm about to challenge you right now.
Go ahead and challenge me. I might not know the answer to your question, but
Well, school, so my sister's a teacher down in North Carolina, and obviously Title IX falls down there.
Mhm.
But when they have a resource officer, that resource officer has a whole different parameter than school administrator would have.
yes, that's true. Yep. So school administrators are looking for violations of school codes of conduct, right? So when a school administrator does, let's say, horrible situation, but let's say you have a sexual assault that happens in the school, right? The police department receives that report because we sent it to them, right? And they are conducting a criminal investigation into that alleged sexual assault. Our Title IX coordinator is also conducting a Title IX investigation to determine whether there has been a sexual assault within the meaning of Title IX. And ultimately, what schools are concerned about is allowing kids to access their education, right? Our burden of proof is different than the police department's burden of proof. And so we don't tend to do these investigations together because we have different standards that we are trying to apply. Sometimes the police officers will tell us, hey, you guys can't investigate right now, right? And we have to wait until the police has finished its criminal investigation before we can conduct our school investigation. But we still have an obligation to put supportive measures in place as soon as we know that something has happened, so that we can make sure that students are able to access their education. But you are absolutely correct that police officers have different obligations than the school does. We have legal obligations, but we're not enforcing the law, right? Police officers are enforcing the law.
Well, I'm just putting, like, so Title IX to them is not a thing, so their definitions, they can actually define what Title IX does not, or refuses to.
So, yeah, like, I don't want to say that they don't care about it because that's probably too strong, but yes, they are not using the same definition necessarily of sexual harassment or sexual assault that we are using under Title IX.
Well, they look at it in criminal terms.
Yes,
Yeah, it's
exactly.
a criminal
Well, I'm
infraction.
just thinking resource.
Right, yeah, I
officer.
understand what you're thinking. It's a criminal infraction as opposed to a federal.
And the resource officer would have to look at it if it rose to the level of a criminal offense.
Right.
They wouldn't just.
Right.
There are a lot of times where something happens in a school and the police do their investigation and they say, we don't have enough to prosecute this, right? And the school gets it back. And then we say, we got plenty because our burden is only 51%, right? We're obligated to do an investigation. We're going to do it. And we only have to be 51% certain that something happened in the manner that is being reported to us, whereas they have to be a lot more certain, right? So we're looking at very different evidentiary burdens.
But then their consequences can be much greater than a school could impose.
For sure,
But
yeah,
the burden's higher,
Right,
yes.
yeah.
and the, the idea behind giving everybody the information and keeping both people access to the education is the concept that you're innocent until you're proven guilty. So
Yes.
although our level of proof of that guilt, quote unquote, is much lower, we still can't presume guilt without having the investigation.
Yes, that's correct. We're prohibited from
Yeah.
presuming that. Yeah. Okay. Other questions about Title IX before we move on to generic harassment is not really a good term, but it's non-Title IX harassment.
It's every other type of.
Yes, every other type of harassment.
Can we get a copy of these slides?
Oh, yes, absolutely, yes. So, oh, no, you don't have to write anything if you don't want to. So as we discussed earlier, state and federal anti-discrimination laws prohibit discrimination in public schools based on certain characteristics. There was a new law that was put in place in New Hampshire in 2018 or 2019, RSA 193-38. That law is specific to school districts and says schools cannot discriminate against students based on their membership in these protected classes. So that's actually, surprisingly, that was a new thing, right? We were relying on Title IX and some other federal anti-discrimination laws, but we didn't have a state law protecting, protecting students until,
Ever on it in Vermont, when I was working over there.
well, maybe we stole yours, I'm not sure, but we now have one. I want to say it was 2018, but I could be off by a year on that. So we can't discriminate based on age, sex, race, creed, color, marital status or familial status, physical or mental disability, religion, or economic status. And of course, when we talk about sex, we are also talking about sexual orientation and gender identity. Those are explicitly protected categories under New Hampshire's non-discrimination law, RSA 193-38, as well as RSA 354A. Harassing conduct is different than bullying because remember when we started talking about bullying, it has to be pupil to pupil, right? And it has to have a particular target. So a pupil has to be a target of that bullying behavior. In harassing conduct, it doesn't have to be directed at a specific individual in order to be considered harassing. So for example, if you have a student who is standing in the middle of the cafeteria shouting the N-word, right? That would be harassing conduct in and of itself. They don't have to be talking to a particular adult, a particular student. Just saying the word is enough to create a harassing environment. It can be physically threatening behavior. It can be harmful. It can be humiliating. It doesn't have to be. The definition of harassment is a lot looser than the definition of sexual harassment under Title IX. Thank you. I told you I talk a lot, so it's good for me to have a break.
Next time we'll bring it down.
Thank you. But it can take a lot of different forms, including verbal statements or graphic and written statements, right? If there have been instances in New Hampshire of swastikas drawn on lockers, right? That is harassing behavior. Harassment rises to the level of illegal harassment or discrimination when the conduct is severe or pervasive or persistent such that it interferes with or limits a student's ability to participate or benefit from services. So that definition sounds familiar, right? That was the alternate definition that we talked about under Title IX, the old definition of sexual harassment. We think that's coming back. And it's already the definition that we're applying when we talk about non-Title IX harassment. So when we talked earlier about a situation where conduct under Title IX is founded, but it doesn't meet that legal definition, right? We can then say, okay, well, what about this one? It might not meet severe and pervasive and objectively offensive, but does it hit this definition? Because if yes, it's still illegal, right? It's still illegal behavior. It's just a different law that we're applying. Schools have to address harassing incidents which it knows about or reasonably should have known about. A companion to that new law that went into place a couple of years ago is RSA 19339, which tells school districts that you have to have an anti-discrimination plan, which is designed to assess and prevent incidents of discrimination. So if you don't have one of those yet, it's something that you certainly would want to think about pretty soon. And once you receive complaints of harassment, school districts have to take immediate and appropriate action to investigate or otherwise determine what occurred. It's not like the bullying law where we have 10 days where we have to get the investigation done, but our investigation does have to be prompt, thorough, and impartial. Are there questions about harassment?
I have a question about it,
Yes.
and I think I know the answer, but. So there are sometimes situations where kids will say, for example, the N-word, and it may in fact be directed to someone, and then they go, but it's okay because Johnny is fine with it. We call each other that all the time. Is that okay?
Well, I would say
Sorry.
your school rules probably do not allow anyone to say that word for any reason, right? And so certainly we should always be taking context into consideration when we are talking about consequences. But you don't have to change the rules for people, right? Just because, you know, women use disparaging words towards each other does not mean that you have to allow anybody in the school environment to use disparaging words, right? So you can still say, don't call each other the B word. I'm consequencing you for calling each other the B word, even if the recipient of the B word is totally fine with it, right? That doesn't mean that you're totally fine with it. And so it is okay for the school to say, I am consequencing this behavior because it is a violation of our school rules. It's not consistent with the environment that we want to create here. But you don't have to ratchet it up to the level of an illegal harassment investigation.
Just a hypothetical.
Just
Kelly
to
had her
the
hand
cat.
up, by the way.
I'm sorry?
A remote board member had her hand up.
Oh, sure.
Hi, Shelley.
Hi, everybody. So when you were talking about Title IX during that investigation process, there were a whole bunch of things that we needed to do for both students, right? In order to kind of keep them separated, protect them, etc. When you went into the hostile harassment piece of it, did those standards still apply?
Good question. So under Title IX, you are absolutely correct. We have that obligation to ensure that we are treating everyone equally throughout the process. If we are doing an investigation under the bullying law, or we're doing an investigation under state law sexual harassment, we don't have those same legal requirements. It is sort of up to the district to consider how consistent do you want to be across the board in your investigations. In other words, you know you have this legal obligation under Title IX. And so do you want to say under state law sexual harassment, you aren't going to treat the complainant and the respondent equitable, i.e. we're allowed to put different burdens on students who are being accused? Do you want to say that in bullying, right? That's kind of up to you to decide how you're going to apply those rules. It is not a legal obligation like it is under Title IX, but there is some benefit to consistency, right? So that everybody knows what the expectation is. However, the piece of the Title IX investigations that I think would be very difficult to impute in other areas is the piece about sharing the evidence, right? So under Title IX, you are required to share the evidence, can't really redact, but that means we are dealing with FERPA in different ways. FERPA is the Federal Education Right to Privacy Act. I was close.
No, you're
Family
right.
Education Right to Privacy.
Okay.
There we go. There we go. So that requires that we redact student information, that we not share student records with parties who have not been appropriately read in, you know, they don't have a legitimate educational interest, or the parents haven't signed a release. So I would think that sharing information in other types of investigations would be a violation of our FERPA obligations. So I think that would be pretty problematic. Does that answer your question, Shelley?
Yes, it does. And would it also be fair to say, when you go to the other level, the not the Title IX, there isn't a difference between report and formal complaint, correct?
That's absolutely correct. You're right.
Thank you.
You're welcome. That's a very good point. So in other contexts, if a student reports sexual harassment to an administrator and the Title IX coordinator meets with the student and the student says, I don't want to write this formal complaint, that does not mean that the student's concerns die in that room, right? The school can still investigate those concerns in other ways. They just can't do it under the Title IX process. Okay.
Does the school have an obligation to investigate?
The school has an obligation to investigate, assuming that the allegations as presented, so you're assuming the allegations are true at the outset, right? And if the allegations at the outset present a colorable claim, right? They present a legitimate claim of bullying, of Title IX, of sexual harassment under state law, then yes, the school has an obligation. So back to our example about, you know, Johnny made fun of me because my snack smelled, you know, weird. Then I would say, you don't have an obligation to do a bullying investigation in that particular context, because even if that is true alone, right, that one single incident does not rise to the level of bullying. If that's the allegation and there are a number of other allegations that come along with it, then I would say, yeah, you probably should treat that as a bullying issue. But in isolation, even if it's true, it doesn't rise to the level of bullying, so you don't have an obligation to treat it that way. Does that make any sense? So the bullying law was put in place in 2012 in New Hampshire to just allow kids to attend public schools that are safe, secure, and peaceful environments, and to protect students from physical, emotional, and psychological violence by dealing with bullying. And the reality was, at the time, bullying was being treated differently all over the state, right? You had some schools that were taking it incredibly seriously, some schools that were taking it, treating it as code of conduct issues. Excuse me. And so this was the legislature's way of saying, we want to prevent bullying from happening in our schools, and we want our schools to be dealing with it consistently. And we as a state want to know how it's trending, right? We want the schools to report data to us to tell us how many claims of bullying are getting.
You want this back?
Think of it, I don't think much cost. Let's see, I usually all kind of check the water.
Thank you very much.
No, that.
So bullying is a single significant incident or a pattern of incidents that involves written, verbal, or electronic communication, or a physical act or gesture, or a combo, right? Has to be directed at another student, has to cause some kind of harm or emotional distress, or interfere with their educational opportunities. I just have some dust in my.
Had some dust in your water.
Tom.
So most of the time, if you have a single incident and it doesn't cause emotional distress, right? And that has to be more than just this hurt my feelings. It has to be genuine emotional distress to the student. We don't have to treat that as bullying. That's a code of conduct issue that our administrators handle probably 1,000 times a day, right? Is that fair, administrative team? Yes.
Yeah.
But when we have more serious conduct, either that's happening in school or at home, and it's impacting the school environment, that's where the school has an obligation to get involved. Bullying includes actions that are motivated by an imbalance of power based on a student's actual or perceived personal characteristics. So even if a student, let's say a student comes to school wearing a political t-shirt, right? And maybe they don't care about the politician who's on that t-shirt. It was just the clean t-shirt that they grabbed off the top of the laundry pile that day, right? But if another student is aggressively awful to that student for wearing that particular t-shirt based on that student's perceived personal characteristics, that's something that could be bullying. The reason that bullying is in a different category is because a lot more behaviors could be considered bullying than could be considered illegal discrimination or harassment, right? You notice that political beliefs was not one of the protected categories when we talked about harassment, but here, a student's perceived belief system, perceived political beliefs could be the basis for bullying. It could be the basis for that imbalance of power. How students dress, how they fit in, right? Those are things that all could be motivation for bullying. The bane of my existence, and probably most of yours also, is cyberbullying, right? Snapchat is a product. Let's leave it at that. The nicest thing I can say. But bullying that happens at home over electronic devices, they don't have to be school controlled electronic devices, they don't have to be school accounts, is still bullying that the school can address if there is an educational impact, right? So if the bullying occurs at home between two students who are sitting in their separate homes, and the students come into school the next day, and you have one kid who says, I cannot focus in my language arts class because I'm sitting right next to Sally, let's give poor Johnny a break. And Sally spent all night sending mean things to me on Snapchat, right? That's something that the school can address if the emotional distress is severe enough.
Can or must?
Right.
Must. It's something that the school must address if the student is alleging behavior that, if we're assuming it's true right at the beginning, right? We're assuming that everything they say is true, then we must address it. If it does not, we know it's bad behavior, but it doesn't rise to the level of bullying, doesn't mean we can't make phone calls home, right? It doesn't mean we can't let parents know what's going on. But you don't have to do a bullying investigation in that particular situation if at the very outset, the allegations do not rise to the level of bullying. So schools can discipline for bullying and cyberbullying that occurs on or is delivered to school property or a school sponsored activity, right? If it happens at your sports games, at your graduation, anything like that, that's still bullying that we can deal with. If it occurs off school property or outside of school property, it has to interfere with the student's educational opportunities or create some kind of substantial disruption of the orderly operations of the school. Sometimes we hear about things like, students being recipients of bullying over the summer, right? And they come in to school and they're actually okay. They don't seem to be having problems with other students, but parents have let us know that something has happened over the summer. If the student does not seem to be unable to access their education at the beginning of the school year, then you don't have to do that bullying investigation right at the start of the school year. If the student says, I cannot be in class with that person because this is what happened to me all summer long, that's a different situation. But if the student is able to access their education, then we don't have to take off-campus activity and bring it onto campus. So, in plain language, right, bullying is unkind behavior toward a student that is spoken, written, texted, emailed, messaged, put on a web page, blogged about, right? Snapchatted, video, TikTok, I don't know. I heard someone say TikTok the other day at one of the hearings and on Capitol Hill, and that gave me anxiety. But TikTok, right? Or there's some kind of physical behavior or a threat of physical behavior, can be at any time, any place, any student, and it has to cause harm to the student in some way in school. There has to be a nexus to the school environment. We can address misbehavior off school grounds that has a significant impact on school grounds, but as you are probably all likely aware, we cannot address every incident of, we cannot and should not address every incident of misbehavior that occurs off school grounds. Students have free speech rights, and so we don't want to take off school grounds behavior and turn them into school issues when there is no nexus to the educational environment. The law prohibits false reports of bullying. So if administrators become aware that a student has made a complaint in bad faith, you can discipline for that. You can discipline for the bad faith. And again, it also prohibits retaliation. I've only gone
Wow.
1 minute over. Thank you. I would be very happy to take any questions that anybody has.
One of the big ones that I see a lot at the middle school level is, you have parents and students come in saying, we'll do Johnny again. Johnny sent my child who Snapchat's the one that Snapchat images or, things, inappropriate things. I saw it, but I can't show it to you because it disappears after whatever,
It
that kind of
does,
stuff. And
yeah.
that's the big one is like, do you have like this information? You can share? Nope, I saw it though. So how far do you, I know obviously we still look into it and everything, but how far in depth do you really go when you don't have all that?
I mean, that would be a claim that would be very difficult to substantiate, right? So again, our burden of proof is 51%. We have to be more sure than not sure that something happened in the way that it's being presented to us. And if we can't get to 51%, then it is an unfounded allegation. In this case, it doesn't even sound like a parent is alleging bullying has occurred, just that the child is receiving inappropriate.
Well, they always come, my child's being bullied,
I see, okay.
they're getting that.
Would it be possible though, and I'm sorry, I don't know Snapchat, I'm not as bad as the US government, but I still know Snapchat. Is it possible that was sent to more people though? So you could do an investigation and say to Sally and Billy and
Yes.
Jeannie, did you guys get this too? And if they're like, yeah, then you're getting higher on your.
Absolutely. And talking generally to the student, right? The allegation may come in through the parent, but we still want to talk to the student and get their perspective on it. The student is the person who is most likely to tell you how it has impacted them.
Yeah.
Right. And so if there is not some level of emotional distress that is a more than hurt feelings level of emotional distress, then, that's.
And that doesn't go away forever. There's an archive folder. Most kids don't know that.
Yeah, I was gonna say Snapchat, I don't think It
The
may-
storyline disappears, but there's an archive.
Right,
over there.
because anything that's ever sent through an electronic means
Yeah, you
has,
can always find it,
has a footprint.
Yeah, you have to,
but you
You have
I
to-
thought you had to do a search warrant. though.
You have to
Yeah, to getting
contact,
getting
right,
it
it's
from
illegal.
Snapchat
Yeah.
is very difficult,
forever.
although not impossible.
Well,
Which,
someone did
which,
it recently.
yeah, what,
Yeah.
the Murdoch murders in,
Maybe it was that.
in South Carolina, but that was the critical piece of evidence,
Yeah,
was that video from
Yeah,
Snapchat.
they don't go away.
no,
Yeah.
nothing goes.
So, no, but you have to, getting it from Snapchat is generally a process, and I have tried before, they have been spectacularally uncooperative, so.
But some kids, if they see something, they will like take a screenshot.
Right.
Yes.
Bring
That's
it
what you
into
try to
us.
teach, yeah, you teach
Yeah.
them, take a
20 years
screenshot if you see it and everything. So
What they have all learned is to take photos with other electronic devices so that there's not the Snapchat screenshot notification.
Mhm.
So
Okay.
it is not uncommon to, if you ask kids for screenshots, they'll say, well, I don't have it because Snapchat won't let me take one without notifying the other person. But they sometimes do have pictures and they are drawing that distinction, right? They're saying, well, it's not a screenshot because I didn't click on my own device, but I did take a picture of my computer. So sometimes that evidence.
Okay.
I take pictures of stuff on the computer all the time. I'm like, oh, yes. It's quick.
Other questions? Yeah, Andy?
I guess what I was hoping to hear tonight, which I don't know if it's even possible, and I don't know if it's a lawyer thing or if it's an administrator thing, but the same thing is happening today that has happened the last 30 or 40 years. And is there any way that the school board or the administrators or the teachers can be able to put some kind of teeth into a consequence that will deter an action? Because words and meetings and workshops and training sessions don't stop this type of behavior.
So what we didn't really get to, right, is what happens at the end if an allegation is founded. If it's unfounded, as we talked about, there are other things that it might be considered as, right? And those behaviors can be considered. If it's founded, my experience has been that that's a pretty serious consequence. School administrators have the ability to suspend for up to 10 days, as you probably know. In certain situations, you can suspend for up to 20 days if the superintendent approves a long-term suspension. He is only allowed to consider long-term suspensions in limited circumstances. So for many Title IX violations that are first offenses, assuming that we're not talking about assault, right? Assuming that we're talking about hostile educational environment, you are looking at a 10-day suspension for that behavior. You're not generally looking at an expulsion unless it follows some other pattern of behavior.
I think the difference, though, to your point, Andy, is that this stuff has gone on for years and years and ever, right? And back when I first started, people were like, well, that's just the way it is, you know, that's boys will be boys and blah, blah, blah. The problem, aside from just being unkind and unmean, is that the reach and the persistence of it is all over the place, right? So if I'm being cyber bullied, that's very different than if I was on the bus in 1970 something.
This is how you know we're not actually siblings.
Correct. If I was on the bus in the 70s, you know, when a kid was giving me grief on the bus, I got off the bus and it was done until the next day. That's not true now, right? It's pervasive, and the only way you get away from it is for you, the individual, to say, okay, well, then I won't do Snapchat, I won't do tic-tac-toe or TikTok or any of those things. So it's the same type of stuff, but it's much more harmful for kids nowadays. But the consequences, I would say they're the same, but I think they're actually getting constrained a little bit. Like, not that the superintendent loved to do this, but the superintendent in the past could suspend for up to 20 days in much more expansive cases. And they keep limiting and limiting and limiting. And same with principals, you know, it used to be you could suspend up to 10 days Now they're changing it so you can suspend up to 10 days in the cumulative. You know, so if I'm going like a day, I used to think that's awesome. And now it doesn't work that way in many cases.
Right. School principals can suspend for immediately, right, on the first instance for health, safety, and welfare violations, which I would argue that a founded Title IX violation after 60 days of investigation, right, where if that's founded conduct, it is a health, safety, or welfare violation. But beyond that, they can suspend up to 10 days for willful and repeated violations of school rules, where graduated sanctions have not worked. So there has been a real movement in Hampshire in the last couple of years away from out of school suspensions. And it has hamstrung administrators across the board and school boards as well. I mean, it's been an interesting result in that in trying to keep more kids in schools and making these rules stricter, they have actually increased expulsions because the superintendent used to have the authority to issue a long-term suspension for a period of, 2 months or 3 months or something like that. Now he can't do that anymore. It's capped at 20 days. And if the offense qualifies for an expulsion, the only option beyond 20 days is to refer it to the school board for expulsion. So it's a much different process now than it even was 3 years ago.
When I worked at Pembroke Academy, we had an in-school suspension. Is that considered the same thing?
Right? Don't they?
We can't do that anymore?
Oh, sorry. Yeah, you can still do an in-school suspension. In-school suspension does not count towards those 10 days of out-of-school suspension. However, there are exceptions to that. So identified students, if they are removed from their placement, placed in in-school suspension, then it counts towards a manifestation determination.
When I have encountered where I think that a student, where it's looking as if where we have kind of a pretty major violation. And then talking with especially if there's going to be any court involvement, it's going to be referred to the police, kind of a thing. I have found that the judges around here really like to have a special ed process start when if a student is going to go to court in any way or be investigated in any way, because they love to have, well, partly because they love to have special ed help pay for the placement, but they are saying that they need to rule out that it's a special education issue, that the student does have the ability to control their behavior. And so is there anything, can you speak to that a little bit, or is that bringing in
It's
a different
not,
person?
well, yes, it is. That is not my area of expertise. But I know probably just enough to be dangerous and not much more than that. But I would say that it is pretty common if we are looking at serious consequences, right? If we're looking at expelling a student, it is pretty common to say, has the student been referred for special ed, especially if we're looking at some kind of a pattern of behavior. We're looking at a one-off and there's no evidence that it's related to any behavior that would qualify for services under the IDEA, then I'm not that concerned about it. But if I'm looking at a pattern of, let's say, increasingly sexualized behavior, I would ask that question, and you as board members should be asking that question. Has this student been through a special ed referral? Because one of your obligations as board members in considering an expulsion is, has the school done everything it can to try to keep this kid within these walls? And if the answer to that is no, then you have to consider whether an expulsion is really the appropriate remedy for the behavior.
Thanks.
Sure.
Once you're done, if there's anything that you want to talk to Megan about in a non-meeting, you can do that. If there's things you don't want to bring up kind of in general, or if there's anything you need to share, that would be more legal advice.
Yeah, I have some thoughts if you have a few non-meeting minutes. not actual minutes.
Yeah,
It's law.
they're not reading, but- Is there any other general questions, comments?
I was just curious for us, here, for our administration, who filled, these three roles? Title IX is what, Chris?
Yeah.
And then the investigator, is it dependent upon the location?
Yep, I'm pretty sure we've done it that
Yes.
way.
Okay, and then the decision maker on whether to, is it dependent upon the,
Correct. Location.
I was appointed decision maker this last one.
Was the
You
last thing that we had, but that doesn't mean, I
And,
think
and in
that,
the future, we've talked about actually including all the principals, because there can be multiple decision makers. Not in the location, but within
sure,
different realms
sure.
to be able to review the report and make a determination of
The more objective.
correct.
Yeah.
We think
And
that.
it can't be that it cannot be the investigator and or
or the appeals
Title
person,
IX.
right? Yeah.
Exactly.
coordinator.
We learned a lot.
We think this distinction is going away,
Right.
for next school year when we get the new rules, so.
Much more
Always.
convoluted than it
It's
was
been
when.
very demanding on very small school districts
Yeah.
that don't have enough administrators to fill all of those roles. So we do think that when the new rules come out, we're going to be looking at a unified investigator decision maker, just like with a bullying investigation, right? It's the same person
Right.
who does the investigation and then decides the outcome. But we don't have those new rules approved yet, so we're not sure.
Thank you.
Do you feel like you got some questions answered, or that you have more questions that came up because of it? I mean,
What she just told me is the school is just hamstrung by federal law. That's what she told me.
It's a state, but yeah.
Sometimes the state, but in this case, yeah, I mean, it's definitely the federal regulations.
Back to the drawing board.
We appreciate you coming. I actually appreciate you bringing up the topic so we could have Megan come. in
very
and
much, I
talk
really
about it.
appreciate you bringing up the topic. I think it's really important to have this discussion. And,
I feel bad that you're gonna walk away with that feeling. And I just hope that you'll continue to keep the lines of communication open with us. Because even though it's a process that seemingly is convoluted, right? And seemingly not fair when you're looking at it from, one or the other sides. I do think, and I don't have the statistics, but I've worked in school districts for 17 years and the administrators around the table have been more than I. When investigations are done properly and right, I think that we can make it better and bring relief. And so if that's not been your, yeah. Yeah,
And I believe I said this last time.
Yeah.
And I know I've said it to Carter once or twice,
sure.
that school is not the problem. It's the nuclear family, it's the home, it's what's happening there is what is like happening in the school. However, I mean, the resource officer would probably be a good ticket, just having that person, you guys use one here, right?
You
Am I wrong?
Sort of. We haven't been able to get one.
Consistently, but
Yeah.
yeah. So, I mean, that's a small, especially for middle school, that would be probably a relatively good deterrent. And would take some of the load off of the principals of whatever school. But she just helped me understand why there's active shooters in schools.
That wasn't her goal, by the way.
Now I understand why, because if everybody is limited to Title IX in every state,
Well, look at what happened in Denver recently. Did you see that?
they had a school.
I
shooting
think
today.
there are other,
That was done in Nashville, yeah, that's a different issue. That wasn't.
well, thank you. Thanks for coming.
No, no.
Thank you. All right, so you'll go into non-meeting, but you don't have to do anything, but just say we're going into non-meeting, right?
Well, you have to adjourn your.
Yeah, well, you have to do that, yeah.
So, Shelley? You still there?
She may have left. Oh, Shelley?
Yes,
you to adjourn?
yes. Yes, I'm here.
You're here, but do you want to move to adjourn?
Oh, sure. Yes, move it.
Okay. So I have to do a roll
Yeah.
call because she's on,
Yes.
just go around. Who else says yes?
Yeah, Teague, yes.
Sarah, yes.
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 Sarah? I'm sorry.
Yes, ma'am.
I apologize.
Yes, sir.
It's okay if you want
Oh,
the
yeah,
admin to stay, they
yeah.
can stay.
You